Hello, legal visionaries. Welcome to episode 7 of the Global Lawyer podcast, which reaches a special milestone today as it coincides with the founding date of the São Paulo Lawyers Institute, 150 years ago. For those of you who don't know me, I am Marina, your host. Yes, 150 years ago, on November 29, 1874, our institute was established with the mission to uphold the rule of law, promote legal knowledge, and foster a commitment to justice. And to celebrate this milestone with us, there's no one better than the resonant, scholarly voice of Professor José Roberto de Castro Neves, who is the living embodiment of the perfect alignment between academic insight and the practical application of the law. Professor José Roberto is a true powerhouse in the world of private law. He is not only a top-tier legal scholar, but also a remarkably versatile thinker. He is known for his groundbreaking interdisciplinary and transdisciplinary approach to the law. His prolific writing output is extraordinary, with nearly a book per year spanning from deeply insightful academic works on civil and contract law to unexpected explorations where he draws connections between the law and the realms like music, literature, film, and the arts. But that's not all. Professor José Roberto is both respected and beloved by his students and colleagues, admired for his mentorship and uncanny ability to spot and recruit brilliant minds for his collective literary projects, many of which become bestsellers, just like his individual publications. Professor José Roberto, welcome. It is a tremendous pleasure to have you here, especially on such a special day.
Well, thank you, Marina. It's a pleasure to be here as well. Thank you for all your compliments. I mean, a big part of it is due to the fact that you're my friend. So thank you so much. It's very kind of you to say so. I didn't know that today was the birthday of the IASP, which is it's a great. It's 150 years. That's an accomplishment. That's great.
That's something, right?
It is. It is. It's extraordinary, really. But thank you so much. It's a pleasure for me to be here today.
Thank you. Now, this episode here won't be like our typical interview because we have already decided that, as you suggested, Professor, we will hold a sort of a flowing lecture here, a flowing lecture where I will gladly jump in on with specific questions here and there as you go along. So this conversation is sure to be a treat from one of the leading lights in legal academia. Well, this setup is inspired by the recently published book, by your recently published book on the interpretation of contractual relationships. So to give us a sweeping overview of this remarkable work in a well-structured and engaging way, we are diving into this important theme with you. So now we are going to let's dive in. And before you take us into this fascinating and challenging journey, I would like to say that I'm almost finished reading your book, which tackles all the intricate questions of contract interpretation head on. In fact, contract interpretation, it's a contractual relationships, the interpretation of the contractual relationships. And I have to say, it's truly impressive, though not surprising, of course, given your extensive and eclectic work. But your keen insight in building the interpretative approach that you propose is quite new. It reflects your tireless analysis of human behavior, its circumstances, and also its consequences, and how you apply this contractual relationship to real life. So I say this because here we are talking about prolonged contractual relationships. In English, we used to say executory contracts as opposed to executed contracts. So executory contracts like contrato de execução diferida, right? Where the parties invariably face uncertainty about future events that might impact their relationship. So my question is, not my question, but it's an observation. So could the need to interpret these prolonged contractual relationships be considered one of the most important evidence, one important evidence that the law is alive and dynamic?
Well, indeed, it is. And it's, well, you said about practice. And when you come to practice, when you have a discussion about a subject that you go to the court or you go to the arbitral tribunal, mostly, Marina, you discuss about two issues. One of them is the law itself, which is what is the length of the law, what the law says in that case, in the particular case, how you're going to rule it. And the other issue, which is very frequent, it's like maybe 50% of the times you're discussing, it's about interpretation of the contract. That is what the parties wanted to settle when they signed the contract. So as a matter of fact, the interpretation of contracts is something that you deal in everyday basis in a court or things like that. So the idea of this work is to establish or try to indicate a way of doing this interpretation for a more precise way, to give some more objectiveness to that daily work of a lawyer.
Right. Now, so you mentioned principles of interpretation. Okay, I'm not going to, I don't want to jump in too far, but there are principles of interpretation that are based on will and reliance, and they must be harmonized in business contracts, where the risks and expectations of the parties may differ substantially over time. How can we do that? How can we strike that balance?
Well, as a matter of fact, what you have to consider most of the time is the will that they had at the time they signed the contract. Because, of course, people change and they interest, they change, they will, they change. But what you have to be in mind when you discuss that is what they had in mind, or what they had in their purpose at the time the contract was done. Exactly.
All right.
So most of the time the discussions happen because, you know, the means they change, the reasoning they change. So people want to say, well, I don't want that anymore. So they maybe tossed a little bit the interpretation of the contract. But the idea is to have it the contract as it was, the will of the parties at the time they've done it.
Okay. All right. So okay, go ahead, please.
Yeah, I was just about to say that basically, one of the important things about actually the title of this work, which I consider to be a correct view of it, is that you don't interpret it only the contract itself. I mean, not the paper that you've signed or but the whole relationship of the contract. And you know, nowadays, Brazilian law, there's a tendency to really look after the behavior of the party, for instance, what they had before and mostly what they behave after the contract was done. So that will also be a part of the interpretation of the contract. What they do and what's I've never explained that in English, so that's I'm bringing out the words here.
No problem. Sure, no
it's
problem.
fine. But just to try to get the words, the proper words here. But the praxis of the market and how the people they behave. So a lot of other issues that are extrinsic. They're not in the contract, but you do pay attention when it comes to interpreting a contract.
Right. And so if I'm not mistaken, you mentioned something like the mitigation of the will. Like, to what extent does it apply in complex contracts involving?
Well, it's the whole thing about this idea of trying to have it done is that, as I mentioned, interpretation is a very important part of the work of a lawyer. They're very important because most of the time, your client comes to you and say, listen, I think that this is what I meant when I wrote this. This is what the parties had in mind at that time, but somehow the other party has a different point of view. And this is what you come to discuss. What is the correct interpretation that each party believes that it's the right way to solve the problem, or to that they have agreed of something different. And that comes to the lawyer, that's a lawyer work, to say what is the right interpretation. And it's very important that you have frames to do that. Otherwise, this interpretation will be flaccid, will be like not a strong thing, but more like a
loose thing.
Really flaccid and like I'm thinking about gelatina here, like
jelly, not jelly,
or something like that. Yeah. So this is not
not
good,
firm.
because
Okay.
Yeah, because what you want when it comes to law, and one of the very most important purposes of the whole law system is to have certainty. Is to have like a social security, and that you know what a court, what a judge would look at this and will say this is what it meant. So to have this correctly, you have to indicate how you interpret it. What are the steps that you have to follow so you have a perfect interpretation? Because you see, Marina, there are many ways to interpret one ruling, one agreement, many ways.
That's right.
And is what I believe is that none of these ways are right in principle. That is, if you want to have a perfect interpretation, you have to look at many ways that you can interpret a clause, and by like a conundrum, like you have it all together, and then after that you say, well, this way, this means something, this means, and then you get to a final. But basically, actually, first of all, it's very interesting to understand the word interpretation, which is a Latin word, for instance.
I'd like to ask you about the word. Very, very nice.
Yeah, but actually, I have two different words. One is called the hermeneutic. It's hermeneutica was in Portuguese, of course. That's a Greek word, and it comes from the god Hermes, which was the god that had this relationship between the gods and the human. So this one that came with the word of the gods. It was the messenger of the gods.
So Hermes.
But of course, the message of the gods were not clear all the time. They're actually on the contrary, they were somehow like mixed and confused. So someone has to interpret it. Someone has to, so like Mercurio, actually, Hermes or Mercurio, Mercury is the Roman name for Hermes. And so many newspapers have the name Mercury, because this comes with the news. That's why the Mercury or something. But interpretation, that's a Latin word. And the reason the etymology, the origin of this is because a long time ago, when you want to foresee the future, you go to a seeker or someone who would like a vite, and this guy would get the animal like a bird and would look at his visceras. What's the name of English?
The guts.
Well, guts, kind of guts, yeah.
Yeah, and not exactly, but
it's not exactly guts.
Yes, okay, but we can. I understood guts. What you mean. Okay.
So and you open this animal or something, and he got his guts, and by that he could foresee the future or say, well, so this is going to happen. So that's interpretare, because he got into
because it was okay.
Oh, his hand. So this was the
through.
So this is the interpretation. It's interesting because that's the origin of the word. but so interpretare means to put the hand
Means to-
inside and try
inside.
to see what was there
And
from
take
the
off
inside.
everything to see what
Pick
what
off and
what
to foresee exactly. So
It's very nice.
it's very interesting as well that you get, of course, the art interpretation, which you're so fond of, but there's a different history here. When you interpret art, you want to something new. You sometimes the artists want you to feel something different,
Yes.
or maybe give you some room for your own interpretation. But when it comes to a contract, the lawyers who've done it, or the party, they don't want to have a big interpretation. They want to make it as clear as possible. So this is a different way of writing it, and of course a different way of reading it. Well, when you read a romance, a book, or a novel, you feel like, oh, you want to think of something different. But when it comes to a contract, there's no room for that. You know, on the very contrary, the ones who did it, they want to make it very clear what they mean. So this is different. But still, even though they want to be clear and they want to be precise, there is, of course, always room for interpretation, because you have to interpret everything. You know, when you read, you interpret it, and the reasons why it's very important for the law, for the system of law, to have a clear interpretation system is, number one, because when you interpret someone, there is a politic or ruling on that. For instance, in Brazil, nowadays, you want to have an interpretation that is social, profitable, a social interpretation. You don't want to interpret anything which is against, social value, for instance.
Yes.
So of course, this
is a strong reference. Yeah.
It's a reference, and it's a principle, and that's a political. So law want to have that as a system. And number two is safety, is uniformization, segurança jurídica.
Yes, legal certainty. Yes, of course.
So this is also another very strong reason why you want to have this eye on having a frame where you should follow it. And you see, there is a very important reason why you have to have a wide look at this today, because as we mentioned just a few minutes before, when you look at a contract, when you look at the relationship, you have to look at all. You don't only look at the contract itself. Like, for instance, I'll give you a very simple example. Sometimes it's written on the contract that, well, for instance, you have to pay your rent on the 5th day of the month. It's written there. But the parties have always, they've always
the tenant has always,
the tenant have paid his landlord always on the 10th for ages, for 10 years.
Right.
And when it comes to what does the contract says, so the party has how to interpret it, you have to look the behavior about the behavior of the party, because then you're going to see what they agreed at the end of the day, which is different from what they've written, but is accordingly to what they have done
in practice.
And it's also very important because when you especially when you're a lawyer, or when you're a judge, or when you are a part of a member of the arbitral tribunal, you have to get away with your prejudices and your nails, psychological nails, because you have to look at this in a very fair way. But what I'm suggesting in this book, that you follow 5 steps of interpretation.
Oh, right.
Okay. And the first one seems easy, which is to identify the will of the parties, which looks like, okay, that's easy. And most of the times it is easy. Sometimes not that easy. But yes, that's something that you have to bear in mind, that the idea of someone who's interpreting a relationship, a contract relationship, is that what the parties wanted, what they will at the time they've signed the contract. So that is which is their job to do so. Okay. And as you know, as law is being developed and nowadays, well, when in the beginning of the 19th century, the whole idea was to find the will, because it was a very liberal society.
Yes.
When the French made their made their code in 1804. This was the most important thing, of course, the will, the liberté, the freedom of contracts. So this was the party have to do. So they have to see what they want at that time. And the will was very important. The will was a manifestation of the liberty of the party. That was a crucial point. So this was damn important. But nowadays, law, at least Brazilian law, as we speak, it's more important of the confidence of the trust the party have. So they will look at what you said, what how you externate doesn't exist.
Yes, how you manifest, when you expressed.
When you manifest your manifestation, how that implied in the other party, but that is how this was absorbed by the other party.
Absorbed by the other party. How did the party read this, or what were exactly conveyed? Yes, transmitted to the other party.
But it's like, so by doing that, of course, you have to see what your manifestation, how it came to the party, and so was it reasonable that other party had some sort of an idea of what you wanted? So the expectation that you bring up when you have an idea. So when you agreed on something, what was the reasonable expectation that your like Jane Austen, so how that expectation has to be delivered, and so this is very important. So this is number one, which seems to be, so this is a clear thing. What is the will of the party? Sometimes it's very easy to find it out. Sometimes that's not. It's a hard job.
Yes.
So this is the first step. And the second step is to understand who are the parties and what are their circumstances. So there's elements that are not on the contract itself, but like, for instance, what the peculiarity of the party, and this like in a relation perspective. For instance, are these parties able to discuss in equal basis the object of the contract, or no? One of the parties is much stronger than the other and has a huge power, and then could easily direct the object of the contract and use its power to basically agree or whatever with the other party. So or no, the other parties, they're very equals, and they have good lawyers. They could help each other, because when you're trying to understand what happened, it's very important to understand all this.
Because the interpretation, so the role of the interpretation in this case would be to level the playing field, I believe.
In a way, yes. In a way, yes. In a way, at least to understand if the other party had a choice and the chance to express its will in a proper way, or was it a difficult moment for this party? So it was hard to express at that time, since to all the circumstances. So this is very important to understand. And the third step is to understand the nature of the business. So see, you haven't looked at anything yet. You haven't looked at any clause yet, but just to understand what the parties, understand the nature of this. For instance, in Brazil, if it is a consumer
matter,
relationship, it will be a different frame. You have a different way to look at it. If it is, for instance, negócio gracioso, like a donation, for instance.
A donation, a gift.
For instance, Brazilian law will have a very, very different way to approach to this. Much more protective to the donator, for instance. So this is something different. And like for instance, like if it's a contrato de adesão,
adhesion agreement, adhesion contract.
Yeah, like a contract in which all the clauses are already done by one of the parties,
like
and the other can only say
express
yes or
your
no.
consent. So you express your consent. So I agree. So you don't have a voice.
So you don't have a voice. Basically, you just either agree or you don't. And many contracts like this nowadays, this mass society of consume. So of course you have to look at it and say, listen, this contract was done by one party and one party alone, and the other party just signed it. So if you have any doubt or discussion on the extension of this clause, well, of course you have to be more kind to the party who did not make this contract.
Because there may be a lot more, let's say, leverage on one side than in the other.
Yeah,
of
course. And of course, if it's a contract done by two big companies, both well served with brilliant lawyers, then of course this is a fair game. Really, it's a different way of approaching to an interpretation.
Sophisticated party.
You come to the fourth and definitely the more interesting step, which is to use several different ways of interpreting a contract, which you have. Okay, and so there's like lots of methods of interpreting a contract, and the first one is of course the literal interpretation, just the reading of the contract. That's a first door, because everything when it comes to interpretation starts by reading the contract.
By a word.
And sometimes it is very clear. And what you could have, and it's a more sophisticated thing to do, but is to have clauses that simplify what you want to do, which is sometimes that you have it in more sophisticated contracts when you say, well, when I say this, I want to mean that. And the contract already explains its ends. No.
Yes, that's when perhaps. Okay, I'm sorry.
No, go ahead.
No.
I'm just saying.
Okay, go ahead.
No, I'm sorry. No, sorry, Marina. Go ahead.
No, I was just saying that some contracts, they usually have at the beginning the definition section. So they have for the avoidance of doubt. So that.
American contracts,
American.
They used to have this. It's a praxis. They definitions of terms that they use. This is not that common in Brazil.
Yes, you are right.
Less common, because that's another thing, that in Brazil you consider that the contract is not a whole itself. You have to interpret it according to the system. While in United States, you think the contract is a whole thing in itself. But anyway, it starts by reading. That's the number one. But again, the reading is sometimes dangerous, because sometimes just when you say something is not clear. I'll give you a silly example of this guy who went to a restaurant, and then it was like this was a plaque saying that if you buy one, let's say, if you buy one piece of meat, you will gain a fish, something like that. And then the guy buys meat and then receives a fish, and he says, well, I want the meat. But I guess, but it's written there, if you buy a meat, you're going to have a fish. So
my God.
Yeah, they said, well, for me, it was clear that when you said that, is that if I buy a meat, I have the meat and the fish.
And the fish. Plus.
Yeah. Like se você comprar pastel de carne, você ganha pastel de queijo. something like that. So it's like, well, that is of course the literal meaning,
The
but that's
literal
not
meaning, yes.
what
Yeah, that's
it
fair
really,
enough.
the intention is different. So this is the first. So, but this anyway is very important, of course. Start by reading it, and the second one, it's like a historical interpretation, and that comes in two ways. Okay, number one is that when you see a contract, you have to understand the historical moment it was done. What was, like, for instance, it was something was done during the pandemics. You have to understand that this clause was during that time, and during that time, lots of special cares were taken into consideration. So you can understand a lot by the time, or during the time of a war, or during the time where a dollar goes
up
to heaven,
skyrockets.
So yeah, so this is something you have to understand. The other thing which is very interesting, also like historic, but in a different way, is when you see how the clause was built. Like, for instance, nowadays, when you discussing a contract and you exchanging drafts, they go forth and back, and normally by email. So you have sort of a history of how they were done, how they were written, and sometimes
also the observations, the notes at the margin,
the notes, and then you can like a historic research, see how they get there, from where it came, and then when you're discussing the interpretation, it is very important to have that file, because you can say, well, this is not what we agreed. This is different from, you see, you want that, and after we changed a lot, we came to a different way. So now you're saying that you want to have an interpretation which is exactly what I did not agree, and I have the evidence of that.
Yes,
so this is
because you have the traces. You have access to the traces.
So this is also it's like a historical thing, also very important to understand how it goes. Number three is the other way of the method is, or ways, is of course the systematic. You have to read the contract as a whole, and sometimes if you take just one clause out of the context, it comes to really crazy. And sometimes that is very important to understand where the clause is, the geography of the contract, for instance, where it is exactly. So you're discussing a clause regarding the penalty if you are late in your payment. This clause could not be applied to other things which is not related to the moment of payment, for instance. So by have a systematic approach, you probably find a lot of what that clause meant, and it's very important.
Right.
It's a very common that you have like a considering or considerandos during the contract.
The recitals, the preamble.
So you say considering this and considering that, and of course, when you interpret it, it's very important to look at those, because nothing that it's written could be against that.
Yes,
because this is the very base of the contract.
There is a legal scholar in the United States, and she says, I don't remember her name, Barbara something. She said that if you, this is in the United States, look, this is not here in Brazil, but if you, in the US, you write recitals. So you see, the parties here too, they agree as this agreement executed on this date, witness it. Whereas this, whereas that. So if you, before the series of whereas, the consideranda, you write recitals, and one of them in the long run proves invalid or null, it could invalidate the whole agreement.
But in Brazil, pretty much the same.
Oh,
in Brazil, the same. If you have like something was like considered to be, well, of course, not all of them, but if you can establish that this was the very ground or the reason why
The
you
contract is made.
agreed upon something, and if that is considered to be invalid, you may very well say that all the contract was invalid because the very basis of it is not considered to be valid
premises,
anymore.
das premissas, right?
Yeah, the very basic premises and all that. So yeah, so there's this, and now there was a recent modification in the civil code, saying something that was not necessary to be said, but just saying now that you can agree upon interpretation rules of your contract. So you can say in a contract, like, for instance, I want this contract to be interpreted that always the parties have to share the risks of the contract. So something that you agreed. So whenever you have a clause in which there's some room for discussion, say, well, listen, we have to interpret it according to that rule of interpretation that was particularly agreed by the parties. So there's something
very interesting. It's something new.
Yeah, it is. Yeah, it is new. Well,
it's from the law,
not,
the economic freedom, the economic.
Exactly. 2019. 2019. Liberdade econômica. Yes.
Yeah.
Yeah, but again, this is something that you could have done long before. It was just stay there. It was not you're not avoid to do that. It's not opposed to do that. But anyway, you can do that. One other way to interpret the contract is by looking at its purposes, teleologic function of the contract. So why you've done that? So when you have a discussion on the extension of the clause, you say, well, my purpose on doing this contract was that. So of course, this interpretation can only be one in which I can reach that purpose. So this is otherwise one way. Yeah. So we say, well, the interpretation is one that I would never get into what my end to my purpose. So this is not a good interpretation because it will be nothing. So like a placebo.
A placebo. I think it's placebo.
Placebo.
Yeah, I think it's so. I think so.
So this is, another way is which is growing in Brazil, which is very strong in America, is the economic interpretation, because you consider that all that you do in terms of course, commercial relationships, they are based on the idea that I will get some advantage, that I will get some gain, some profit on my business. So when you interpret it, you have to look that you've done that, you did that, looking after this profit. So if you cannot interpret a contract in which you're going to have like a loss.
A loss.
It makes no sense.
Yes, it makes no sense.
You do it because you will gain something.
Yes, you have something in your mind. Yes, that's the reason.
So this is also when it comes to, well, what is the proper way to read this clause? It must be a clause in which you're going to get some money, you're going to get some profit, you're going to get some gain. Otherwise, it makes no sense. No, you're not a ONG or not a ONG. I don't know.
Yes, ONG.
So you want to do something about it. So this is there's a economic rationality on the contract. Other way that you use a contract is in the practice of the market. How does the market behave to one thing, which is sometimes even the party that they don't even say something because they don't need to, because that's the way the parties behave, that the market behave. So the behavior of the contract, the way things normally happen, this is very important. The Romans would say, quod plerumque accidit, which is the way it normally goes, which is of course very important to interpret the contract as well. So there's another way to do it. Another way is to act in good faith.
Yes, this one is very, very important.
It is in Brazil. It is, and it's growing a lot, and it's very interesting when you consider that 30 years ago there was no good faith there's not an issue. There's not a point. So this is
No one would talk
it
about
was
that.
it was incorporated in Brazilian law only in the Código de Defesa do Consumidor,
Yes.
1990. And today it's very hard to say something to take a step in civil contracts without the idea of bona fide, of good faith. So this is crucial as well. And when you look at a contract, you have to consider that the parties are acting in good faith. So if you have an interpretation which admit that the party was doing like a smart guy, was not working fair, makes no sense. This is probably going to be for a good law, a good judge, but look at it and say, no, I don't agree with that. This will not. I have like the ethics matter involved in law, which is a signal for me of civilization. You know, we're looking more at the ethics than we were, 100 years ago, 50 years ago in terms of civil law. So yes, so when you have sometimes you have a doubt in what is the proper interpretation of a clause, and you say, well, if you have this approach, then it's completely against good faith, so it makes no sense.
Yeah.
You agree that one party is taking some advantage on the other, basic on his being smart, so just because he was more, exactly, like not fair. I don't. That's very important as well. So and another way. So I'm giving you many ways of interpretation.
But all of these, they belong to the methods step.
They're all methods,
right?
yeah. So on the fourth step.
The fourth step, right? Yeah.
And the other, the last one, it's relates to the continuity and the maintenance of the effects of the clause, because sometimes one party advocates that this contract has a meaning which has no effect at all. Sometimes it says, well, this is the interpretation of the contract, and the other party says, well, if that is interpretation of the contract, we're all stupid because this it has no practical effect. So another way of getting out the best interpretation is to get interpretation which makes sense. There's a very famous French jurist, Potier, Robert José Potier. He wrote this rules of interpretation in 17 something. And one of them, actually, the second one, is that when you have two ways of interpreting a clause, and both of them make sense, you have to choose the one that get out some effect of the contract. And of course, reject the one interpretation that has no practical effects, because that's so clear that if the parties agree to sit down and write something, it's because they want some effect. If they don't want anything, they simply would never sign a contract. So this is you see, all these ways that I mentioned, the literal, the historic, the systematic, the teleologic, the economics, the good faith, the practice of the market, and the behavior, the conservation, the conservative contract, all of them, they're very important. And in fact, the best thing, if you want to get a real effect of a clause, is to try them all. Is to look at the contract and see how the contract would react to this way or to that way. And by having this, after you finish, you're probably going to see what fits better, what regarding the will of the party and the nature of the contract, the aspect of the party, which of them is the best one. One thing that's probably going to get to a mistake is when you look at the clause and you simply say, well, you know what, I'm going to have a literal interpretation, and you forget the others. Or, okay, I'll interpret as it's a good faith. And then you take good faith and you forget all the others. and that's probably going to lead you to a mistake, because sometimes all of them together will give you a best approach, a best
Yes, they are. In
answer.
fact, the contract is a whole. It is a whole.
Not only because of the systematic approach, which is very important, but also because all these ways, they show you some aspects of the contracts, like this very famous and ode, Indian tale, that the blind, lots of 3 or 4 blind old men, they found an elephant, and each one was saying, "What is this?" And one of them got this tail, so, well, this is a stick, and the other got this, I call it tromba,
this trunk.
The trunk, and say, "Well, this is a snake or something," and the other got his feet. So this is a tree, and so on. And the other is just, this is a wall. So if you look for many ways, then you probably have a better view of the whole situation. So the idea is that you have to get aware of all these methods of interpretation, because sometimes people just ignore them. And by that, you have to get into what is the best way by going to all this. But there's also the fifth step, and the last one, which is related to some corrections. Because sometimes you have one approach, you're happy with that, but that's, for instance, is against the law.
Right.
Or the law would not accept that. Or maybe also because sometimes you have a way that you interpret a contract, but the parties have acted in a very different way. So
this corrective interpretation would be made by the court, I believe.
Well, by the court, but sometimes even the parties could go before.
The parties themselves can do that.
Yeah, of course. I think that should be different. And even sometimes there is no, which is also very common. Sometimes the contract doesn't explain one particular situation, and you will probably have to find in the contract itself the answer of the science. For instance, sometimes the contract says it's very common in Brazil that for one clause the contract says which index you're going to use to have a monetary correction, for instance, which is very common in Brazil. So use that index to have this monetary correction. But then on another part of the contract, you don't do anything. You don't give any index. How the parties would fulfill that gap, that lapse, that gap, that hole. Probably using by the same index that he used in some other part of the contract. So you use the contract to solve the problem itself. But just to finish, it is interesting that the interpretation of the contract, it's have some similarities, of course, in the interpretation of the law, but some things are very different sometimes.
Yeah, how so?
For instance, when you interpreted a contract or a contract relationship, you have to look what is the will of the parties. And when you look, and of course it's more private thing. They have interest, they have their wills, they have objectives and purposes that are particular to them.
Yeah.
But when you interpret a law, you don't have to think of anyone but the man legis, the interest of the law, which is of course much more social than the private interest that go to law. So it's a different way of approaching. One of them is
another perspective. Yes,
it's more particular to that case, whether you have to think of the particularities in the contract interpretation, whereas in law you have to look at the general interest.
The big picture.
There's the big picture of the general interest, not looking at someone particularly, but as the society as a whole. And finally, we just mentioned this before, but when you look at the contract, you have to see what the parties wanted at the time they signed it. Whereas the law, as Pontes de Miranda would say, the law has to be interpreted with the eyes of the time. Com os olhos do seu tempo, with the eyes of its time. So one law had one meaning, and maybe 20 years later, due
It may
to
have another
several
one.
aspects, it could have another meaning, where the will of the parties is at that time. It doesn't matter if they change it. Well, it's irrelevant for the interpretation. So, but the whole thing is that I think that if you want to trust in the contract, it is very important to have a frame of interpretation that someone would know that if there is a discussion, honest discussion on the meaning of the clause, he will know what kind of discussion he will face. So what kind of issues will be discussed to interpret, to get the really meaning of the clause. And for that, we have to discuss these issues, we have to know them, to understand them. So that is, at the end of the day, will guarantee a more safe market.
Yes,
And that's it.
a safe environment for players.
Yeah, of course.
And
of course.
also which would lead to legal certainty.
Yeah, so you know what you'll discuss. You know what will be at stake if you have a discussion of that issue, of that nature.
Right. And there are so many things here in my in my mind, because I've been working with international contracts for the past almost 20 years, and I have faced numerous challenges in terms of both language and legal concepts. And this is so interesting. So in the context of international contracts, now, going a broader environment, to what extent can translation be considered a barrier to the faithful interpretation of the will of the parties? And what would be the best practice to mitigate these linguistic ambiguities? Because it has to do, of course, with the legal system itself as well.
Of course. You see, this is a very practical issue, but many times you see like a bicolunado contract, and contract which you have like
in two columns,
English
so
and Portuguese,
or
whatever, and Portuguese. But then you have two, and then you normally you say, which is a more sophisticated and a good thing to do, say, in case of a doubt, the English version will prevail.
Yes.
So then,
to avoid.
But of course, sometimes the translation would help to interpret it, even the English version. Because you say, because you see, this is what written, but see how they translated. That is more clear in Portuguese and in English, and
than in
sometimes
English,
the other way around.
Yes, depending on who wrote the contract, who drafted it. And could we perhaps see a trend towards more standardized terminology to minimize these risks in the future? Do you believe this is going to evolve, or not?
Yeah, I think that that English would become like a Esperanto, or the common language, even more. And so I think that we use it in English more and more, because nowadays even the Chinese are working in English. So, well.
Yeah, that's right. And even the soft law also helps. You see, if I'm not mistaken, the UNIDROIT that they have, UNIDROIT, yeah. They do have something on interpretation, don't they?
A lot, yeah, a lot. I mentioned it a lot in the books, because you see, they have a lot of it, yeah, which is good,
which also make things easier.
But you see, many different systems, they have rules of interpretation. Our system do not have many. Should have more. But it's just that Brazilian system, it do not have, it not work with many ways of interpretation. It should.
Right. And there are also many other. I was thinking here about a difference that might exist between what is just as opposed to what is correct. Now I'm talking about let me see if I can explain myself. When it comes to pacta sunt servanda, sometimes what is just because of if you think of a hardship that the parties face, so it might be just for the contract to have a flexible interpretation, so to not to cause a overburden on one of the parties. Whereas the correct interpretation would be to follow the letter of the contract. So there would be a difference, or
but this is like this fifth step, which is the correction.
Yes,
Of
the correction. Yes.
Yeah.
You can.
Yeah, so
Yes, you solve
sometimes
this. Yes, you are right. You already solved that.
sometimes you have a contract which is against the law or against a very important principle, and then the judge or who's ruling it have to understand whether it's possible to make it survive, or if it's completely
Yes.
against the law, then no, this is a null contract because it's objected against the law. Or, well, I can adjust it so it can get some effect, so we have a legal effect. But of course, when is doing this is a very dangerous thing, because you cannot make a new contract. But
Right.
but this is something very interesting, and something that we should really pay more attention and to discuss it in order to get this more strong frame on when it comes to interpretation of contract.
Yes, and when you mentioned the integrative interpretation would be, so the role of judicial review of a business contract. So can judicial review based on integrative interpretation affect or adversely affect legal certainty or the predictability of business in Brazil?
That's a very critical issue, Marina, because when you have like a integrative interpretation occurs when you have a vacuum on the contract, something that the parties did not agree upon, but they need to have some agreement, otherwise the contract would not be making any effect. So when a party says, well, I want to have some interpretation judge that would make this work, and by then judge will have to really look and try to get some elements from the contract itself to fulfill that gap if possible. The danger here is when judge fulfills it and makes a new thing, makes a much more complex, much more expensive for one of the parties.
Yes,
and that is something which is very dangerous. So by doing that, and this is very delicate, he needs to do that with a lot of sensitiveness and intelligence. So he not create a new thing which was not under the party's idea or will.
Yes, the judge should investigate the source of the solution. The judge should dive into the contract itself to see if he finds something there.
But just to finalize it, it is all these tools. They're very rich and very useful, but all of this comes much colorful when you get a practical
issue. Yes.
So when you have the case, the concrete case, then this conversation gets much more interesting. Because then you can look at this and see how that would work. And it's just very interesting, and say, well, I understand now what you mean by having an economic interpretation, because that's the only way this could make sense.
Yes, each default or each dispute is a whole unique universe of the parties.
Sure.
So we have
but that's it. That's very interesting, and it's And I hope, yeah,
Okay.
we had it
Yes.
was a good conversation with
Oh,
you.
it was fantastic, fantastic. I loved it. It is so good. And as I said, your approach and your proposal to offer a roadmap, or so to speak, a process to interpret, it's very enlightening and very soothing, because, oh, thank God we know we have a step-by-step solution for these so difficult
This puzzle
issue.
sometimes, yeah.
Yes, sometimes it is a puzzle. So as we wrap up today's enlightening episode, I'd like to extend a warm thank you to you, Professor José Roberto, for sharing your profound insights on the interpretation of contractual relationships in your interconnected global landscape. And by global here, I don't mean only territorial. I mean global and holistic and everything encompassing, all encompassing. Your presentation was not only enriching and clarifying, but also strikingly innovative. So while
very kind of you, Marina, it's always a pleasure to be with you, and I think same things about you. So it's very kind of you. Thank you so much.
Oh, no, not at all. It has been a true privilege, and you are here, really. You have. It was a privilege to have such a thought leader with us today. That's the word, a thought leader. So thank you so much again, Professor José Roberto, and to all our viewers. I leave you with a final thought. Stay curious and keep questioning. Just like the law, life itself also demands a great deal of interpretation, refined and thoughtful interpretation. So it is essential to remain vigilant and responsive to new events and their potential legal implications, right? So by staying engaged and informed, we not only become better practitioners, but also contribute to the evolution of our legal system. Thank you for joining us today, and until next time, keep exploring the endless possibilities of the legal world. Thank you. Bye-bye.
Bye-bye. Bye.